Good evening. Welcome to the arguments of the Kansas Supreme Court. I'm Doug Shima, clerk of the Kansas Appellate Courts, and I'd first like to introduce the Honorable Timothy Chambers. He's going to give you a small introduction of the cases you're going to hear today.
Welcome, everyone. It's certainly a unique opportunity we have tonight in Hutchinson to view the Supreme Court. The court is going to hear two cases tonight, a criminal case and a civil case. In the criminal case, it comes out of Butler County. A Butler County police officer stopped a pickup truck for the driver and passenger not wearing a seatbelt. He gave the ticket to the driver, asked the driver, "Can I talk to you a little bit? Can I search your truck?" He said, "Fine." So the officer told the passenger and driver to go to the front of the vehicle and wait there. They searched the truck, found a meth pipe, and the officer then went around to the passenger, Mr. Cleverly, the defendant appellant, and said, "Is it okay if I search you?" He said yes, searched him, nothing there. The officer then asked, "Can I search your package of cigarettes?" Mr. Cleverly said yes. Inside the package of cigarettes was a small package of methamphetamine. Mr. Cleverly was arrested for possession of methamphetamine. He argued at the district court level that that was an illegal search. Both the district court judge and the Court of Appeals held that the search was legal. Court of Appeals said that they should not have patted him down, that there was no indication that he was armed or dangerous, but that had no effect since he voluntarily gave permission to search himself in the packet. So the issue for the court to decide in that case was Mr. Cleverly being illegally detained by the police officer in violation of his Fourth Amendment rights against search and seizure, therefore making the search of the cigarette pack illegal. That's the issue there. Second case is a civil case, a little more complicated. In a civil case, somebody is suing somebody for money. It can be a private person, it can be a company. In the case tonight, we're dealing with companies. Basically, and I need this chart because this is a little complicated. Hospitality is a company in Wichita who builds hotels. They were building a Holiday Inn Express. They hired the Putes contractor to build the building. Putes hired Dynamic Drywall to put the walls in the building, and Dynamic Drywall went to Wagner Interior to purchase the supplies. The hotel was built, and Hospitality paid Putes, who paid Dynamic, and then Dynamic went bankrupt, belly up, and didn't pay Wagner. So Wagner was out their $100,000 bill. This is a case where nobody's at fault as far as the parties here, but somebody's going to end up losing $100,000. To complicate matters, Hospitality, who now had their hotel, wanted to sell it. Wagner, to protect its rights, filed what is called a mechanics lien against the people above it. So Hospitality couldn't sell its building because there was a lien on it filed by Wagner. There's a specific statute that allows for this situation, and what Putes did to help Hospitality is they filed a release from lien bond, and they had United Fire Casualty file the bond. So then we come to the next stage. Wagner then goes after United Fire for the bond. Putes says, wait a minute, when Wagner filed the mechanics lien, they messed it up and did not file the right paperwork, that they had the wrong parties, that in fact they had Dynamic as the contractor and Putes as the owner rather than Hospitality. So you went into the district court. The district court judge held that Putes wins because the lien wasn't any good. Because the lien isn't any good, the bond isn't any good. Therefore, Putes wins. Wagner appealed. The Court of Appeals says no. The statute that allows for this says once the bond is filed, then don't think about the mechanics lien anymore. It's out the window and you're just going solely on the bond. So they reverse the Court of Appeals and Wagner wins. So the issue for the Supreme Court tonight is when you file a release from lien bond, according to statute, does that release the mechanics lien entirety, and it doesn't make any difference whether the people properly filed the mechanics lien? In simplest terms, it involves a statute, and if you put it down to its basics, the Supreme Court has to interpret this small portion of a statute that says, which is disputed by the owner or contractor. What the Supreme Court decides that means will decide the case as to who of the two parties loses the $100,000. I can tell you, having been a lawyer for 40 years, I've read all the briefs. There are excellent briefs filed by all parties in these cases. Obviously, excellent attorneys going to make their argument. This will give you your chance to view how our system of justice operates. Thank you.
Thank you, Judge. And the attorneys down here were saying, well, if it was only that easy. I have a couple housekeeping items just to make sure we get through before we start. This is a court of law, and we ask that you stand when the court comes in. The honorary bailiff is Ruth Lloyd. When the court comes to the curtain, that she's going to say, "All rise." So at that point, please all rise as the court enters. Remain standing until the Chief Justice announces to be seated. Also, if you must leave during the presentation, please do so quietly, not to interrupt the lawyers as they are arguing. And lastly, these darn cell phones, they go off at the most inopportune times. So make sure that your cell phone is completely powered off. That's what we ask, is that during this presentation, there's no auto recording unless permitted and with given permission. But other than that, there's no audio recording or anything of the presentation today. So make sure everything is powered off completely, because the last thing you want is that to go off during the argument. Other than that, welcome to the Kansas Court of Appeals, and the court will be in session at 6:30. sir, go ahead and say all rise. Okay, go ahead, all rise.
All rise.
Gavel 3 times.
The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Now sitting.
Thank you. Please be seated. Good evening. Welcome to the special session of the Kansas Supreme Court. We're very pleased to be holding this session in the B.J. Warner Recital Hall in the Stringer Fine Arts Center at Hutchinson Community College. Since 2011, our court has made an effort to be more accessible to the people that we serve, and this outreach effort helps Kansans learn about our court and the role of the judicial branch of government. For example, tonight we will not do a public opinion survey or ask you to tell us how you think we should decide the case, but we will ask the attorneys questions in order to do our job, which is to support the Constitution, to uphold the rule of law, and to make the decisions that they require, and not make our decisions based on things such as our personal beliefs or political considerations or special interests. We strive to maintain the fair and impartial courts in Kansas. This is the Supreme Court's first visit to Hutchinson in our 155-year history. And this is only the 5th time in our history that we have heard cases being argued in the evening. We have held special sessions in a variety of communities across the state, starting in my hometown of Salina and in Greensburg, Overland Park, Wichita, Pittsburgh, Kansas City, Hayes, Garden City, Topeka, and Hiawatha. To paraphrase an old Beach Boys song, we get around. Before we go any further, it's my privilege to introduce the jurists who are sitting on the bench with me this evening, and I will start by seniority. To my immediate right is our Senior Associate Justice. This is Justice Marla Lukert. Her hometown is Goodland on the far western border of the state. Next is the jurist to my left. This is Carol Beyer. She is from Kansas City, Kansas, on the far eastern border of the state. To Justice Beyer's left, this is Justice Lee Johnson. He is from the southern border of our state, hometown Caldwell. To the far right is Justice Dan Biles. His hometown is El Dorado. And to the far left is Justice Caleb Stiegel. His hometown is in Lawrence. And the jurist I skipped over is because he is sitting in for our regular colleague, Justice Eric Rosen. And this is the Honorable David Stutzman, a longtime district judge in Manhattan, Kansas. And his claim to fame before that was he is a native of Hutchinson, Kansas, and he is a graduate of Hutchinson High School. So Judge Stutzman helped us fill in for Justice Rosen's opening just in the last day or so. And I want to take this opportunity publicly to thank Judge Stutzman for helping out the Supreme Court this evening. An event like this takes a tremendous amount of planning, and I'd like to thank publicly those people who work so hard to make this a successful event. Starting, of course, a big thank you to Hutchinson Community College President Dr. Carter File and all of your staff who assisted with the arrangements. You've gone out of your way to help our staff plan this event, and we appreciate your hard work and enthusiasm. We extend a warm welcome to President File, the College Board of Trustees, and the educators, staff, and students who are in attendance this evening. This session is being video streamed. We appreciate the expertise of the college staff for making these arrangements. I also want to thank all law enforcement and security personnel who are in attendance, and a special thank you to Chief Dick Heitschmidt of the Hutchinson Police Department, Sheriff Randy Henderson of the Reno County Sheriff's Office, and Captain Dennis Martin of the Kansas Highway Patrol. Also welcome Chief Judge Patricia Mackey-Dick and the other judges and court staff of the 27th Judicial District here in Reno County who are in attendance. Thank you for your assistance with this event. Also wanted to have a short welcome to the members of the Reno County Bar Association. The justices thoroughly enjoyed our visit with you today and lunch at the Prairie Dunes Country Club. And also a very special thank you to our honorary bailiff, Ruth Lloyd. She's the one who called us into session. Ruth has served the state of Kansas for 43 years, and for 38 of those years she has worked for the Kansas Judicial Branch. She is retiring on October 31st, just a few short weeks away. Ruth, congratulations on your many years of service to the state of Kansas, and we thank you for opening our session this evening. I wanted to also mention that before we came on the bench this afternoon, the justices teamed up with your local judges, and they visited area schools to make presentations. And as usual, they thoroughly enjoyed their visits with the students and the teachers. Hutchinson Community College here, Justice Caleb Stiegel was assisted by District Judge Timothy Chambers in their presentation. Central Christian High School, this was Justice Biles and District Judge Joseph McCarville. Bueller High School, Chief Judge Patty Mackey-Dick and District Judge Trish Rose and former District Judge, now State Representative Steve Becker. Neckerson High School was Justice Lukert. Pretty Prairie High School, Justice Johnson and District Magistrate Judge Cheryl Allen. Haven High School, Justice Beyer. Students from Hutchinson High School joined the students here at the college this afternoon for that presentation. We estimate that more than 700 students attended those special presentations this afternoon. I want to thank you all for coming this evening. With your help, this should be a great session, and you will be helping to make history for the first court visit in Hutchinson. We want to remind you that we have a reception in the Gallery Theater immediately following the oral arguments this evening, and we welcome the opportunity to visit with each of you. With those announcements being said, I will now ask Mr. Doug Shima, the clerk of the Kansas Supreme Court, to do the honor of calling this evening's docket. Mr. Shima.
Thank you, Your Honor. May it please the court. The docket for Tuesday, October 4th, 2016 consists of two cases. Appeal number 111282, State of Kansas versus Gerald E. Cleverly, Jr., Butler County. Briefs both sides.
Good evening. May it please the court. Carol Longenecker-Schmidt of the Kansas Appellate Defender Office, representing Gerald Cleverly, present and ready for argument.
May it please the court, Joseph Penny for the state of Kansas, present and ready for argument.
Second case, appeal number 113037, Wagner Interior Supply of Wichita versus Puetz Corporation and United Fire and Casualty Company, Sedgwick County. Briefs both sides.
May it please the court, Ryan Peck for petitioner Puetz Corporation and United Fire Casualty Company, here and ready for argument.
May it please the court, Vincent O'Flaherty on behalf of the original appellant, Wagner Interior Supply of Kansas City, present and ready for argument.
Your Honor, that concludes the docket for today.
Thank you, Mr. Shima. We will be proceeding directly from the first case into the second. In other words, we will not be taking a break in between those cases. If for some reason you feel you must leave, please try to do so quietly so not to disrupt the proceedings. Can you hear me now? No? That's probably good for you. I just want to conclude by saying that tonight you're going to hear but 2 cases of about 125 cases that this court hears oral arguments on every year. And these 2 cases represent more than 200 cases that we make decisions on every year. And obviously, some of those cases do not have oral arguments, but we make our decision based upon the written briefs that are submitted by the parties. All right. With that, I will call the first case on this evening's docket. That's case number 111282, State of Kansas v. Gerald Cleverly, Jr.
May it please the Court, Carol Longenecker Schmidt, again of the Kansas Appellate Defender Office, representing Gerald Cleverly. Mr. Chief Justice, I would like to reserve 3 minutes for rebuttal.
3 minutes. Counsel, I'm having a little trouble hearing you. Anybody in the audience having the same problem? Okay,
I will, oh, there we go.
very good.
I'll speak up and lean in. The main question in this case is whether, when a car is stopped and a passenger consents to answer additional questions, does that consent necessarily transfer to a passenger? In this case, Mr. Cleverly's motion to suppress was denied in the district court. And on appeal, the Court of Appeals, affirmed the district court's denial of Mr. Cleverly's motion to suppress. I have 2 tasks tonight. The first is to argue that the encounter between officers and Mr. Cleverly was not consensual, and was in fact an illegal detention. And that illegal detention tainted Mr. Cleverly's subsequent consent to the search of his cigarette packages. The Court of Appeals in the present case held that the encounter was consensual. And interestingly, the court stated that because when a car is stopped, a passenger is necessarily seized. Therefore, when a driver consents, the passenger necessarily also consents to additional questioning. However, there is no support for this proposition. In fact, it counters the standard that we apply when determining whether an encounter was consensual. And that standard is whether, under the totality of the circumstances, a reasonable person would have felt free to end the encounter with officers. The relevant factors that this court articulated in State v. Thompson to determine whether an encounter is consensual or a detention include things such as whether a person had knowledge of the right to refuse instructions by officers, whether there was clear communication that a person was free to leave, whether a person's license and documents had been returned, any physical disengagement that occurred between the end of the traffic stop and additional questioning. In addition, factors that indicate that a detention occurred include things such as the number of officers, whether they had weapons and whether they displayed those weapons, prolonged possession or keeping of a person's personal belongings, such as the driver's license or other personal effects, such as a purse, interaction that occurred in a non-public place, any physical touching of a passenger or a driver. And in the present case, the application of those factors from Thompson apply to reach the conclusion that this was in fact not a consensual encounter, but an illegal detention.
Counselor, can I review after the driver said he was answering a few more questions, the passenger both the passenger was patted down without consent. The officer put his hands on the passenger without
those are the main factors. In addition, there was no testimony that Mr. Cleverly was told that he was free to leave. There's no testimony that Mr. Cleverly heard the driver consent to additional questioning and search of the car. It's not entirely clear from the record whether that consent occurred when the driver and Mr. Cleverly.
We've lost our sound again. Do we have somebody who can help us out here? I can forfeit my First Amendment rights to freedom of speech and volunteer my microphone if you like. No, they can't hear you when you're facing this direction. Could we just move this mic over there for her? There's another.
Okay, I think I'm on. All right. Justice Johnson, I believe you were asking for additional circumstances. And I was mentioning that there's no testimony in the record to indicate whether Mr. Cleverly heard the driver give consent. And I think that if the state had proved that Mr. Cleverly was standing nearby the driver and heard the driver say, yes, I will consent, I will answer your additional questions, you can search the truck. Maybe if there was testimony indicating what the exchange was, if the Officer Buckley had said to the driver, will you consent, and you're not obligated to consent, but we don't have any of that. We don't know. In fact, the testimony is that Officer Buckley only dealt with the driver and did not have any interactions with Mr. Cleverly, which would indicate that the consent was a conversation that just occurred between the driver and Officer Buckley, and that there's no evidence that Mr. Cleverly was aware of that. I don't know if there is specific testimony to indicate that. I think it's implied. Once the driver was arrested, he was placed in the back of Officer Buckley's car. Yes. Yes, that is correct. Mhm. Yes. I don't know. I can try to review the record and answer that question in rebuttal. But off the top of my head, I don't think, I believe Officer Buckley communicated to Officer Humming that the stop was for seatbelts, failure to wear seatbelts, and that the driver didn't have proof of insurance. But I do not know the answer to your question about furtive movements. I believe several minutes after the stop. That's correct, yes. I think it's unclear. There's testimony, the officers testified that they subjectively did not intend to issue a ticket for failure to wear a seatbelt, but I don't know that there's testimony that the officers told Mr. Cleverly, we are not going to issue a ticket for failure to wear a seatbelt. And so looking at all of these circumstances together, the argument here is that no reasonable person would have felt free to terminate the encounter. Specifically, when you add all these circumstances to the sort of standard show of authority that police exhibit when they stop someone, there's just a certain authority that officers have. And so when you add that to the circumstances that I've mentioned, to the fact that it was 1:15 a.m. at night, January 30th, it was dark, not allowed to use the phone, all of these things taken together would not have led a reasonable person to believe that he or she could end the encounter. And
Mr. Cleverly thought he was under some sort of control because he asked permission to smoke, he asked permission to use a cell phone. It doesn't sound like anyone believes that they have free will at that point. But our test is objective, not subjective. So where does that fit in? When he takes, says things and acts as if he's being detained, how does that factor into our calculus?
I think his subjective understanding is just one factor. True, we're objectively looking at the actions of the officers and how a reasonable person would view those actions. I think if he subjectively believed he was being detained, it's evidence of how he was reacting to officers. If somebody asks, may I please, use my phone, that's probably in reaction to a show of authority, to a feeling of detention. And it's true, that's a subjective feeling, but it's in reaction to objective actions that are occurring. Yes, Your Honor, I believe that's correct. And Officer Hummig also testified later that generally he tells every person he stops to leave his or her cell phone on the hood of the car and doesn't generally permit people to make phone calls during arrests. So I think, yes, I think the key is the answer in restricting Mr. Cleverly's ability to make a phone call and in restricting his freedom of movement. And so the next question here is, if the seizure is illegal, if this is an illegal detention, what effect does that have on Mr. Cleverly's subsequent consent to the search of his cigarette packs? The state must prove that the consent was freely given and that it wasn't a product of coercion, express or implied. And here the state has not done that. The three attenuation factors that are articulated in Brown versus Illinois and more recently in Utah versus Strife apply here. And if you apply those three factors, the conclusion is that the consent was in fact tainted. Three factors being temporal proximity, intervening circumstances, and the flagrancy of police misconduct. We don't have testimony, we don't have a specific timeline, but the whole of the testimony implies that it was a relatively short period of time. It certainly was not hours. And in Utah versus Strife, the United States Supreme Court pointed to the under 2 hours. What? Oh. I'll just try to briefly conclude. The consent occurred during the illegal detention. It was proximate, it was close, there was not a great amount of time. There were no intervening circumstances. The state and the Court of Appeals pointed to the presence of the meth pipe. However, that meth pipe does nothing to break the causal connection between the illegal detention and the consent. So if the main question here is whether the consent was not a product of coercion, whether it was freely given, The presence of this meth pipe does not change that analysis. It doesn't change the coercive environment that Mr. Cleverly was in. And then I think the pat down, I think it's relevant in two different areas. Backing up to the question of illegal detention, I think it's relevant that officers put their hands on Mr. Cleverly. That's a restriction of his movement, and that shows detention. In the attenuation analysis, I think it's most relevant under the flagrancy prong, because here we not only have an illegal detention, but an illegal pat-down that was conducted simply because Mr. Cleverly was wearing a baggy shirt.
Didn't they begin, Officer Buckley tell Officer Emmett that it was his goal to get consent to search the car, and what we have is attempting to search a vehicle for a seatbelt violation, where there's no proof of that particular defect.
Yes, yes. And so, because the attenuation factors don't break the causal connection between the detention and the consent, the fruit of the illegal detention, being the meth found in the cigarette packages, should have been suppressed. The state hasn't met its burden in showing that the search and seizure were lawful, and so therefore Mr. Cleverly respectfully requests that this court reverse the district court's denial of his motion to suppress.
Justice Nuss, the mics, your all mics are not working. I don't know if you're aware of that. You can't hear the questions being asked of the lawyers. Yes, it is.
talking, talking into mic number 6, talking, talking, talking into mic number 6. Talk. This one?
Testing 1 2, testing 1 2, testing 1 2, testing 1 2. 2, testing 1 2, testing 1 2. Testing 1 2, testing 1 2. Testing 1 2, testing 1 2. Testing 1 2, testing 1 2.
If you guys could take your seats and be ready when the chorus comes back. And let's give these audio guys a big round of applause for getting this done.
Thank you. Please be seated. I understand we're now ready for the state's argument. Please proceed.
Thank you, Chief Justice, and good evening. May it please the court, counsel. I'll say, and I told opposing counsel this earlier, I spent part of my car ride here trying to remember to say good evening rather than good morning, so I suppose regardless of how the rest of this goes, I got that. As far as my presentation today, I'd like to kind of take my arguments in a bit of a funnel, starting with what I see as the broadest possible justification for the law enforcement actions in this case, and then moving down to the narrowest justification. I think for purposes of a signpost, I believe the broadest justification is the fact that the officers objectively would have had reason to arrest Mr. Cleverly pretty early on after the inception of this event. And so as a result, any actions that they took that didn't go beyond what would be appropriate in an arrest were constitutionally valid.
Why?
Well, Your Honor, I think that with regard to our determination of whether there's a constitutional violation with law enforcement actions, with searches, seizures, detentions, arrests, and those sorts of things, we look at an objective standard.
No, but why would the fact that he could have been arrested make any difference? Are you arguing inevitable discovery upon arrest?
It's not inevitable discovery that I'm arguing, Your Honor. I think it's more related to the concept in the Devon Peck case that I cited in my brief. Essentially, individual who can be arrested, their access to some of their constitutional rights with regard to right to be free of seizure, right to be free of search is impacted. Individual who can be arrested can be searched. Individual who can be arrested can also be detained. And I think, I noted it in my brief, but I think I have it here too. There's the Scott case in the material that indicates that the fact that the reasons that we kind of hypothecate for an officer to take an action aren't kind of the subjective reasons that the officer believed he was taking the actions, or not kind of the subjective intent of the officer, doesn't really matter. So if the circumstances here, our detention, if the circumstances here have a search and an arrest was valid that includes both of those things, I think that the officer's actions then aren't constitutionally inappropriate, regardless of if the officers believed they were arresting Mr. Cleverly or had any intent to arrest Mr. Cleverly, and I think it's clear from the record that they did not.
So you're saying that if he had been arrested for the seatbelt, they could have searched the cigarette pack as a search incident to arrest?
Well, Your Honor, I think that, ultimately, I think it's still appropriate to maybe consider that under the consent rubric, but I think that a lot of the other events that occurred that Mr. Cleverly complains about, whether he was directed out of the car, whether he was patted down, whether he was told not to use a phone, those sorts of things.
Well, let's go back. You said the broadest justification is he could have been arrested. And I'm trying to determine why that would, standing alone, have win the case for you.
Sure. I think essentially my position is that, when an officer does something, we look for an objective justification.
That if somebody is arrested, can you always search the personal items they have with them?
I think when a person's arrested, you can always conduct a search incident to that arrest that wouldn't go beyond what the pat-down was here. Ultimately, you do have consent as well for the search of the cigarette packs, although, I don't know that there's really any indication that they aren't in the wingspan, but I think just
Well, that's the point I'm getting to,
Sure.
that items that are outside the reach are not subject to a search simply because of arrest. And
Sure.
so I'm trying to get your argument why the potential for arrest absolves the necessity for getting a warrant, because we start with the premise that all warrantless searches are per se unreasonable, correct?
Correct.
So you have to get into an exception. And I'm trying to find out why the possibility of arrest gets you to an exception.
Sure. I think my argument is that Mr. Cleverly's complaint about the search of the cigarette packs that he gave consent to is essentially that, he gave consent, but that consent was tainted because the officers acted inappropriately leading up to that. So, if we look at what Mr. Cleverly alleges that these officers did, he alleges that they detained him, he alleges that they searched him without cause. So, I think we take those things and we look and see if there's a valid justification for the officers to do either of those things. And in this case, there was. There's the fact that Mr. Cleverly had committed a misdemeanor crime. So a person who's committed a misdemeanor crime in view of law enforcement can be detained, can in fact be arrested. They can also be subject to a limited search incident to that arrest.
Even if they're lawfully detained, there are constraints on searches, aren't there?
There are.
Okay.
There are. I certainly think there are limits, and I think it's possible that the search of the cigarette packs would not be a search that would be available as a search incident to arrest. But I do think the pat-down would have been appropriate then, and I think that the search of his person would have been appropriate. And if those things are appropriate, then I think some of the things that Mr. Cleverly complains about, I was treated in an illegal, inappropriate fashion, thus tainting my later consent, aren't there anymore. So, we're left with that consent. A person in custody certainly can consent, if the factors there show that his will isn't overborne. So that's my argument with regard to the fact that he could have been arrested, Your Honor.
You're just trying to take some of the factors off of the table.
Yes,
the
Justice,
factors that you want us to put on the ledger and consider whether there was consent.
That's correct, Justice.
Did you make that argument at the district court?
No, Your Honor, I did not make the argument at the district court. It is an argument that's been in the brief, was made to the Court of Appeals. I think that this court can consider that, however, because ultimately the district court did grant or deny the motion to suppress. So this court could find that the district court was right for the wrong reason, that the outcome was correct, and then that was the justification for the outcome. And I think that, I will note there's the State v. Spagnola case that the Court of Appeals cited. I think that kind of ties into that argument, too. There's a point in the syllabus of that case that essentially says if individual's involved in a car stop or something and they don't have probable cause to arrest someone, they merely have suspicion of illegal activity, then the officer cannot investigate those suspicions by means that approach the condition of arrest. I think this is kind of the other side of it, where an officer does have justification to arrest, so I think under those circumstances, they're free to investigate any suspicions they have by means that approach that condition of arrest. I will say, and kind of moving down the funnel to maybe my next argument, that I don't know if that is necessary to uphold the district court here. I think that these actions here really didn't get close to being a full-on arrest, or we're as serious as we might expect from a full-on arrest, so perhaps that argument's kind of a larger tool than is necessary to deny the defendant's motion to suppress. I think that this is also can be explained through consent or voluntary consent in the encounter between law enforcement and Mr. Cleverly. I think that's true as well.
At what point do you feel the voluntary encounter began?
I believe that this became a voluntary encounter between law enforcement and the individuals in the truck or at the truck at the point in time where Officer Buckley completed the traffic ticket, had the driver sign it, gave him the ticket, and essentially concluded the encounter, and then asked him if he'd have time for more questions. Or at least at that point, the seizure stopped. And I think there's two ways to look at that. One way is, I think, essentially the way the Court of Appeals interpreted it, in their opinion, basically as a corollary to Brindlin v. California. The idea that if one stops a car, even simply to investigate the driver, you seize the driver and you also seize the passenger, just sort of de facto by result.
How does it follow from that the driver has the ability to consent on behalf of the passenger?
Well, I'm not sure that the driver has the ability to consent, but I think the driver has the ability to turn this into a voluntary encounter. So seizure of the passenger kind of flows from seizure of the driver under Brindlin. Then, seizure of the driver ends when the voluntary encounter starts, when in this case, Officer Buckley gives him his ticket and then closes that encounter, but asks if he has time for more questions.
But at that point, didn't the officer ask Mr. Cleverly to exit the car and tell Mr. Cleverly where to stand?
Your Honor, I think that ultimately both occupants in the car were asked to exit the car. I think they were told a location to stand. But I think that's the authority there is part of the driver's authority in essentially continuing this encounter and giving consent to law enforcement officers to search his vehicle. The driver's got dominion over the vehicle, and the driver's allowing the officers to search the vehicle. Doing so is necessarily going to require the occupants to exit. So, I think...
Here the driver was arrested before the discovery of the drugs in the cigarette pack.
That's true. The driver was arrested.
If you're going to use the corollary that the stop of the driver is a seizure of the passenger, therefore consent to voluntary encounter makes the passenger status voluntary, why isn't the arrest of the driver morph it back into a detention? Because the driver's back into a detention. If you're going to have the passenger status vicarious to the driver's status, then he was arrested at the time. But he wasn't arrested.
I think the difference is that there's just this Brindlin case law with regard to traffic stops. I don't think there's any similar case law that would say if one person's arrested, all persons with, who are near to that arrest are also arrested or
Your
seized.
position is essentially that passengers are free to walk away.
Yes, Your Honor, or Justice, I think that is true. And I think that kind of
Help me understand how that relates to your first argument, which was that the defendant was subject to being arrested.
Well,
It strikes me that
sure.
you're making a sort of heads I win, tails you lose argument, right?
It's an alternate argument, I think, more than if that's
Well,
true.
the state can't have it both ways, can it? He can't both be subject to being under arrest and free to leave.
Sure.
Can he?
He cannot, although there are individuals who are subject to being under arrest who ultimately aren't arrested. I think that, the circumstances here and the other way to look at the consent or voluntary encounter, at least that this isn't a seizure anymore, is to kind of go through this court's State v. Reason case and the U.S. Supreme Court's INS v. Delgado case, and then a couple of cases that deal with bus stops or bus searches in Florida, Florida v. Bostick, and then U.S. v. Drayton. And, I think what those cases all basically say is that a person can be in a position where they don't desire to leave somewhere, they're not in a position to leave somewhere, and law enforcement can be interacting with the person, under those circumstances, but that doesn't necessarily mean that the person's then seized by law enforcement.
But in this case, as a practical matter, Mr. Cleverly was refused the right to use his cell phone.
Mr. Cleverly did ask if he could make a phone call. I think did ask if he could smoke a cigarette as well.
But the phone call, if he had had an Uber app, he could have had a ride to get out of there, but the refusal to let him phone a friend to pick him up or use Uber, basically, it wasn't the circumstance of the driver being detained solely that left him in a lurch at the scene, was it?
Well, Your Honor, I think that I don't know that there's any indication on the record that that would be something that he would be seeking to do or that he would be trying to alter his plan of travel at that point. I mean, I think, at least as near as I can tell from the record, that that's something that occurs before the driver's arrested. I think before it's clear that the kind of route of being Mr. Jones' passenger is no longer going to be a route of travel that's available for Mr. Cleverly.
Well, at the least, though, it was delayed, right? And isn't your argument that, your Bostick argument, or Bostick, I'm not sure how to pronounce it, I mean, in essence, you're saying, well, it wasn't the police detaining him, it was that he made a bad call on who to drive him. And the driver decided to let the police delay him, and it's really the driver detaining him, not the police. Isn't that your argument?
Yes, Justice. I think essentially that's, why Mr. Cleverly
So as soon as the driver decided that, he may have opted for something else had he had the use of his telephone. We just don't know.
Sure. I don't know that that's developed as far as what he was trying to do with it. I do think the circumstances where Mr. Cleverly, asks law enforcement, can I use the phone now? And they say, well, not until after we're done searching, or yes, you can use it, but not until we're done searching. You can use the phone later. I think that's different than if he'd, just tried to use the phone and then been out and out prevented by law enforcement. And I don't know that that necessarily means that that's a seizure. Asking that simply could be the setting. I certainly at this point wouldn't get out my phone and take a phone call or wouldn't smoke a cigarette without asking someone's permission.
And why wouldn't you do that?
Well,
Isn't that because you would have a reasonable view that you were not free to do that?
Your Honor, I think it is, but I think it's also part of the setting. I mean, I don't feel seized per se, and perhaps that's not a great example, but if I was in a restaurant and under the same circumstances and I asked my dining companion, can I make a phone call, can I smoke a cigarette, and they said no, or they said I'd prefer you do it afterwards or do it afterwards. I think that's sort of the setting, but it's not necessarily that I feel seized or under their control.
Counsel, I'm going to make this the last question. What are you asking this court to do?
Your Honor, I'm asking the court to affirm the opinion by the Court of Appeals and the District Court. I do think that this was an appropriate search. I do think that I'll stand on my brief with regard to the attenuation argument, but I think there's attenuating factors too, and I think this was a voluntary encounter.
And just so the audience is clear, what is the practical result if we do affirm those two lower courts?
Sure. The practical result, if the two lower courts are affirmed, is that Mr. Cleverly's conviction, ultimately for possession of methamphetamine, would also be affirmed.
Because the evidence would not be suppressed.
Yes, Your Honor.
All right. Very good. Thank you, counsel.
Thank you.
Reserve 3 minutes for rebuttal.
Just briefly, Your Honors. This situation is different than asking your dining companion whether you can make a phone call. Here, Mr. Cleverly was asking an officer, a uniformed officer who was armed, whether he could make a phone call, and that officer told him no. I'm unfamiliar with the tests that the state is putting forth about whether officers' actions were appropriate or there was a valid justification. I think the only question here is whether, in the totality of the circumstances, a reasonable person would have felt free to enter the encounter, and our argument is no. The state had the burden to prove this, that the search and seizure were lawful, and they did not. And so we simply request that the district court's denial of this motion to suppress be reversed. And with that, I would waive the remainder of my rebuttal.
Do we have any more questions of counsel?
My understanding of the state's argument is because they could have arrested the seatbelt, that would justify continued detention, pat down, other action. Because they could have arrested. And how do you respond to that?
I have never heard that argument. My understanding is if there is a search that is conducted without a warrant, it needs to fit into one of the exceptions. Consent, search incident to arrest, inevitable discovery, probable cause plus exigent circumstances, and none of these. The only one that's applicable here is consent, and our argument is that consent is tainted. The officers could have extended the stop if they had reasonable suspicion that Mr. Cleverly had committed an additional crime, but their testimony at the suppression hearing was that there was no suspicion that Mr. Cleverly had committed an additional crime.
Thank you, counsel. The court will take this matter under advisement, and we thank both you and your opposing counsel for your arguments this evening. I now call the second and the last case on this evening's docket. That is case number 113037, Wagner Interior Supply of Wichita, Inc. v. Putz Corporation and United Fire and Casualty Company.
Mr. Chief Justice, and may it please the court. Counsel, may I reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. Ryan Peck for petitioners, Putz Corporation, and United Fire and Casualty Company. Excuse me. In 2005, the Kansas legislature amended KSA 601110 to create a whole new type of bond, a narrow lien release bond, one that allows contractors and owners to bond around any mechanics lien which is disputed. Wagner Interior Supply argues that this new type of bond applies to only certain types of lien disputes and does not apply to the most common type of lien disputes, and in fact results in the waiver of those defenses involving failure to comply with the strict statutory requirements under the mechanics lien statutes. We, on the other hand, submit that revised KSA 601110 applies to any lien which is disputed for any reason. We believe that because ours is the only interpretation that accomplishes the following three things. Number one, our interpretation is the only one that is supported by the plain language of the revised statute. Number two, our interpretation preserves the claims and defenses of all of the parties, not just one or the other. It satisfies all of the competing interests in the case while the disputed lien is litigated. And number three, it frees up the property to be transferred, to be refinanced, to be put to some other better, more useful purpose. With regard to the plain language, revised KSA 601110 reads in relevant part, the contractor or owner may execute a bond to any person claiming a lien which is disputed by the owner or contractor. A lien which is disputed. That's what we must determine the meaning of in order to decide this case. There's nothing in the revised statute that suggests in any way that the legislature intended to limit the types of disputed liens to which this type of new bond is applicable. There's no limiting language whatsoever in the statute. By arguing that this new lien release bond applies to only certain types of lien disputes, Wagner is reading language into the statute that does not exist. If the legislature had intended to limit the types of disputed liens that were covered, it would have explicitly said so in the statute. It would have said that it only applies to certain types of liens which are disputed. It would have said that it applies to a lien which is disputed except as to perfection or any other strict statutory requirements. The only way that the plain English words that the legislature used is to find that this new lien release bond applies to any lien which is disputed for any reason. There is no limitation in the statute with regard to that. Wagner relies on this court's 1984 decision in the Bob Eldridge construction case. While the facts of that case are similar to the facts in this case, there's one big key difference: the language of the statute. When Eldridge was decided, the only bond that was provided for under the statute was one to the, quote, state of Kansas for the use of all persons in whose favor liens might accrue by virtue of this act.
Counselor,
Yes.
under Eldridge, or under the language in effect when Eldridge was decided, would the result be the same here if the contractor had proceeded under the first sentence? Whereby the contractor can cover all liens by putting the contract price in. The first sentence of the statute says you could substitute the bond for all claims as long as it's in the amount of, at least in the amount of the contract.
If the statute hadn't been amended in 2005 to allow...
No. I'm saying if the contractor in this case, instead of singling out the drywall
Sure.
or Wagner, had posted the bond to release all liens like the statute was for Eldridge, which language was not changed in 2005, would Eldridge control?
Eldridge would control. Nothing about our interpretation...
So what we're saying here is if the anomaly that if the contractor goes against one, they could challenge the perfection, but if they go against all of them, they can't challenge the perfection.
Your
Is that
Honor,
what you're saying?
actually, I think I disagree with that premise. I think there's a fundamental difference between the two type of bonds that are now provided for in revised 601110. What you have with the first type of bond that's provided for in the first part of 601110 that was in place at the time of Eldridge and was the only bond that was provided for under Eldridge. That bond, the fundamental purpose of that bond is it's analogous to a performance bond, or in public projects context, a public works bond. Typically, it's one that is filed at the beginning of a project. Everybody is on notice. Everybody knows that they lose the right to file a mechanics lien. Instead, they're making the claim against the bond. But in 2005, the legislature created this new type of bond that allows a contractor or owner to bond around any lien that is disputed.
But
And
they
there's,
didn't change the label. It's still called the release of lien bond. They didn't change the label in 2005. They didn't change the language about discharging the liens. So I'm failing to see where the plain language sets up the dual types of bonds that you're arguing.
I think the plain language of the statute sets up those two types of bonds. And the fact that the statute says that a lien is discharged, it's discharged from the property. I mean, we don't dispute that. The lien is effectively discharged from the property and essentially transferred to the bond so that the validity of the lien can be challenged in the bond litigation. At that point, there is no reason to encumber the property. Everybody's interests are satisfied with the posting of the bond. You've got the supplier who wants to get paid, and now they've got a guaranteed source of payment in the sense of that bond. But then you also have a property owner, in this case, who wants to refinance the property, who wants to convert the financing from construction financing to traditional long-term financing, and cannot do that with a cloud on the title. And what the legislature did in 2005 is they created this new type of bond that results really in a win-win situation for everybody. It satisfies everyone's competing interests and allows for the freeing up of the property, the providing of a guaranteed source of funds for the claimant if the lien proves valid. There is simply no reason to differentiate between the types of liens which are disputed. And there's nothing...
The claim here is for $108,000 and change. But how much was the project, the total project? Millions?
I believe it was over $1 million.
And these bonds are the premium is calculated on a percent of the amount of bond.
That is correct, Your Honor.
So we're talking about with this change, the contractor no longer had to file a release of liens bond in the amount of millions of dollars when it wanted to protect against a 100,000 bond. So there's a very real reason in my mind why they added this language to allow a contractor to keep or an owner to keep the property being tied up for a claim that's 1/100th of the value of the property. Why isn't that the obvious purpose on the face of the statute when you read it? Is that the first type of bond that you're saying, the first type, has to be in the entire amount of the contract. The second bond is in just simply the amount of the disputed claim.
Your Honor, I respectfully disagree, and the reason is because of the plain language of the statute. The legislature provided for a bond as to any lien which is disputed. It didn't say with regard to any lien that is disputed as to perfection, as to the strict statutory requirements for perfecting a lien. It said with respect to any lien which is disputed. There is no other way to interpret that language.
Well, certainly there is, that instead of doing all the liens, you can just do the ones that are disputed. instead of protecting or transferring the liens from property to the bond, you could do it on just the disputed bonds. You didn't have to do it on the ones that weren't disputed. If I'm going to pay off $9 million to contractors because I don't dispute it, but there's this $100,000, then I can file it on that disputed without having to follow the language that it existed before, which was total contract.
But then what we have is exactly what we're suggesting, where you've got a single lien which is disputed, and you now have the ability to post a bond in order to just discharge that lien which is disputed. There is no reason to differentiate between the types of liens which are disputed.
Types of disputes.
Excuse
the types
me.
of disputes, really,
Thank
what
you,
you're
Your
talking
Honor.
about. But can I just go back out a little bit to the
Absolutely.
30,000-foot level? Okay, so it sounds like to me you listed three arguments at the beginning, and the first one is a statutory interpretation argument. And your assertion is the language is plain, and it favors my client's position. Your opponent obviously has exactly the opposite view. The language is plain, and it favors my client's position. Okay, so that's argument number one. It sounded to me as though argument number 2 and 3 are both policy arguments.
Yes, Your Honor.
You agree with me on that?
Yes.
Okay, so I want to put those aside for a moment and return to argument number 1 on the plain language. And just assume with me, for purposes of argument, that we're not going to buy that it's plain for either side.
Okay.
We're going to say, no, when we have two able lawyers who show up and say it's absolutely plain and it favors my client, and they're diametrically opposed, we have a lack of clarity in the statutory language. So just assume that with me for purposes of argument. Then what do you say to us? Where do we go after that?
Well, what I say to that is, I think you have to take a step. I mean, obviously, if the language is ambiguous, then typically you would look beyond the language of the statute. You'd look to legislative history. If there is any, there is scant legislative history, not surprisingly, with regard to this. This was part of a bigger piece of legislation that was enacted in 2005, and the legislative history makes specific references to other statutes that were amended, but there is no mention whatsoever about KSA 601110.
And it appears that those amendments were at least in part directed at a case from the Court of Appeals that was fairly recent, as opposed to correcting a holding from this court that was a couple of decades old, right?
Yes, there was certainly reference to the mutual savings case in some of the committee minutes.
Okay, and we just don't have that kind of reference to Eldridge.
We don't have any legislative history with regard to Eldridge or 601110. So what we have is there's certainly nothing in the legislative history that conflicts or contradicts the interpretation that we're advancing, that the plain language of the statute allows for the posting of bond with regard to any lien which is disputed for any reason.
What else?
Sorry, go ahead.
No, just what else do you have? Do you have some canons of construction to which you would
Well,
direct us?
what I have is, I think you need to take a step back and just think about the common sense practical application of this. If you scour the case law in Kansas with regard to mechanics lien disputes, the vast majority of those disputes are with regard to failure to comply with the strict statutory requirements to create a lien. So if what we're going to do is, it could not have been the legislature's intent to prohibit the bonding around of what turns out to be the most common type of lien dispute that comes before the courts. That could not have been the legislature's intention, and there's nothing in the statute to suggest that.
Why do we even begin to talk about what the statute provides when you entered a bond with very broad language about any claim upon which the lien is based? Isn't that broad language contractually bind you regardless of what the statute did?
I believe that the bond was directed to Wagner in this case. It wasn't the kind of bond that was utilized in Eldridge, the kind of bond that still exists at the beginning of the statute, that's directed to the state of Kansas and is available for use by anybody who may accrue a lien. Did I answer your question, Justice Lukert?
Yes.
Okay, thank you.
We'll make that the last question. You're about 3 minutes over time. Do you need 30 seconds to wrap up and tell us where you want us to be, or do you want to save that for rebuttal?
I'll save that for rebuttal, Your Honor.
Very well. Thank you, counsel.
Thank you.
May it please the court. Again, Vince O'Flaherty representing the unpaid materials supplier, Wagner Interior Supply. Your Honors, we ask you to affirm two long-standing rules of law in Kansas in this case. First, that when a bond is filed, the statutory lien requirements are waived and need not be complied with. And second, that statutes are interpreted based upon the words as they appear and not on words not readily found in that statute. Now, with respect to that first rule of law, since 1984, Kansas has had a clear and predictable interpretation of 60-11-10. The Eldridge opinion provided a straightforward, predictable result.
Counsel, I agree with you that Eldridge has a straightforward rule. Does it come out of the statutory language, or was it just the court developing its own, what amounts to a common law rule with respect to these issues?
Well, they relied upon the Murphy case, which dated back even further, but I do believe it's based upon the statute, and they were not just creating it out.
So direct me to the statutory language, either pre-2005 or post-amendment in 2005, from which you could justify the Eldridge rule.
The language that I would point you to, Your Honor, is first the title of the statute, bond to secure payment of claims. And then second, the language that is contained that says that when a bond is approved and filed, no lien shall attach under the Act, and any filed lien, and I'm paraphrasing here, but it says such liens are discharged. And it was that discharge language and the interpretation of the earlier statute where they talked about all persons in whom's favor liens might accrue. And they focused on those group of persons, that group of persons, and in Kansas, back in the Eldridge case, an unpaid material supplier to a subcontractor was in the group of persons that could file a lien and was entitled to, and that's what the Supreme Court, that language they tied to.
Is it a fair summary to say that, well, the Ellsworth Court talked about waiver of lien requirements and we no longer apply the rules of strict construction? I mean, it sounds to me like what you're really saying is essentially the rule is we are now proceeding under a different instrument, the bond, and whatever happened with regard to the lien is essentially irrelevant.
That's exactly right, Your Honor. Yes, sir.
The liens were originally put in place, a statutory lien, in order to ensure payment. And the bond substitutes for the lien on the property.
Yes, sir.
And, I mean, that's the purpose.
The bond stands in the place of the lien.
And normally we would call it a claim against the bond rather than a lien on the bond, because lien is typically a term we use to encumber property.
Yes, sir.
Rather than a guarantee, and the bond's just a guarantee.
The bond is an
Guarantee
insurance
we're gonna
company
pay.
saying we'll pay. Yes, sir.
What I'm bothered by here is, it seems to me your interpretation creates an opportunity for mischief, where someone who would be entitled to file a mechanic's lien doesn't do it correctly. And then when the property owner wants to refinance, comes in with a defective lien, but ties up the property owner's ability to get clear title to the next mortgage holder, and all the defenses are waived. The procedural defects are waived in that circumstance, and that doesn't seem right.
No, it isn't right, but that's not how I'm reading the statute, Your Honor. The one thing that your question leaves out of the mix is the following. In the real world, the contract, if there's a obviously defective lien, the contractor has a choice. They either can take this bond and go to the district court and file it and have the court discharge the lien, or if they want to refinance the property, they can go to a title company, escrow money, write my client a letter saying your lien's defective, you better release it or you're going to get sued for slander of title, and take that dispute into the title insurance side, and the property can be freely transferred. Our interpretation says that if you're going to, as a contractor, make the business decision, which is what Putz did here, to take this bond and file it and stop our ability as an unpaid contractor to pursue the lien right, then you got to play by the rules. And the rules are now the strict construction requirements of the lien statute are waived. You still can challenge whether our materials went to the site, whether they were improved. All your defenses are not completely waived. You still have defenses to the bond. So we believe our interpretation is correct under the law.
But why force that alternative? Why can't we just leave everybody's claim in place and move forward on the bond as the surety?
Well, because now you're transferring this whole fight about whether the lien is valid or not into a bond proceeding. And the bond's a separate contract. It's got separate language, and now you're having to deal with the statute and a contract, and you're adding confusion to the mix. The statute was originally passed to stop all that confusion, to help contractors and owners get clarity in the situation, and that's what Eldridge did. That was what the last 30 years has been and should continue to be, and that's what we're asking this court to do here in this case.
That gives new leverage then to someone who has defectively tried to file a lien and didn't comply with the statute, and then you've got, in this case, an owner who needs to refinance and really doesn't have maybe the opportunity or time financially to wait to litigate that lien as you suggest, and so they're kind of between the rock and the hard place. We either give in, file the bond, and under your interpretation say waive any claim that that statute wasn't complied with, or go ahead and take the time and litigate and hope your new financing still hangs around when you're done. Seems like you're writing the mechanics lien perfection requirements out of the statute in that case, and they must be there for a reason.
Well, Your Honor, I understand what you're saying here. The petitioner in this case is not the owner, it's the contractor.
I understand that.
And at least in our reading of the statute, and I respect Justice Breyer's statement about when two sides disagree, you may have an ambiguity, but the statute clearly says, as we're reading it, as interpreted by Eldridge, that those strict requirements of the lien statute were in fact waived, that Eldridge stood for that for 30 years, and the change in the statute didn't change that. If that leaves the situation where a contractor that has an arguably defective lien benefiting by the bond, then so be it. My client didn't make the business decision to file the bond.
But I think that's where you walk into Justice Stiegel's point, that Eldridge may have come at a time when the court was reading putting additional words in the statute, and that the policy that came out of it may not have been the product of the plain language of the statute. Get me your result from the plain language of the statute, and nowhere else.
Well, first of all here, the first sentence, my client is any person claiming a lien. And it is disputed by the owner or contractor. And a bond was filed in this case that was conditioned for payment of such claim. So in the first sentence of the statute, we rely upon that. Then you jump
How,
to the
how
second
does that, but
sentence.
how does that get you a waiver of your defects, of your procedural defects?
You have to read the statute as a whole. You can't just
I'm
pick
trying
up.
to.
And so if you go to the third sentence that has the discharge language in it, where it says, when bond is approved and filed, which is what happened here, no lien for the labor, equipment, material, or supplies under contract or claim described or referred to in the bond shall attach under this act. And if when such bond is filed, liens have already been filed, such liens are discharged. That's the language, Your Honor. It does not say perfected liens. The contractor here wants to add the word perfected to this statute and say that because our lien was not perfected, that we lose. But the statute doesn't say perfected. It says liens. What we had at the time this bond was filed was an unperfected lien. That's the language I rely upon, Your Honor.
Do mechanics liens attach to the real estate before they are perfected?
Yes. But then, in order to foreclose, you need to have a perfected lien. But there is an attachment under the eyes of the law, Your Honor. Yes, sir. We've been looking at the language of the statute, and if I could comment upon the 2005 amendments. There's nothing about the 2005 amendments that changed Eldridge. Our position here is that the language that was added was merely a continuation of the existing law. The amendments in 2005 did not replace, did not change the existing law. That the amendment added to the group of persons that are protected under the statute. And Justice Johnson mentioned it earlier. Originally, the bond had to be posted for the full amount of the contract and had to protect all contractors. The 2005 amendment allowed for an owner or contractor to get a very specific bond just in the amount of one lien, thereby lowering its costs. It doesn't have to bond a $2 million job, it's bonding a $100,000 claim. And that was, the purpose of that is to give an owner the ability to deal with the priority of liens and the disputes that arose in the mutual savings case in 2004, which was an earlier filed lien, contractors being able to jump over a bank mortgage and get ahead of the bank, and the bankers didn't like that. So this language was added to give contractors the ability to control the priority of liens and to protect mortgages. So when counsel says that the plain language of the statute supports their position, we respectfully disagree, and the legislative history disagrees with them too. And we suggest, Your Honors, that even though I do not contend the statute is ambiguous, that you're entitled to look at the legislative history to put the historical perspective of these changes in place, not to necessarily interpret the statute. We've also said, Your Honors, and my time is short, but getting to the second reason that we've asked, the second rule of law we're asking you to reaffirm in this case, and that is statutes should be interpreted based on the words as they appear and not on the words not readily found. Again, our position is that the word perfected appears nowhere in the statute. You cannot interpret under the rules of construction in the state of Kansas. You must give the words used their ordinary meaning. You cannot add words to the statute, and you must read the statute in pari materiale, as a whole, and not in isolation. The insurance company, the surety, and the contractor are asking you to select one clause in this statute and take it out of context. We ask you not to do that. In conclusion, Your Honors, we ask that you reverse the finding of summary judgment by the District Court of Sedgwick County. The District Court found in favor of the contractor. We're asking you to reverse that. We're asking you to find that Wagner Interior Supply is entitled to recover under the bond. And finally, we're asking you to send this case back to Sedgwick County so as to calculate the amount of interest and attorney's fees and other recoverable costs that are entitled under this case.
That would be affirm the Court of Appeals.
And in conclusion, to affirm the Court of Appeals in totality. Yes, Your Honor. My time is up, unless there's any further questions, Your Honor. Thank you.
See none. Thank you, counsel. You reserve 3 minutes for rebuttal.
Your Honors, if you take a step back and you look at the purpose of 601110, the purpose is to clear title to property, while at the same time maintaining the status quo so that all of the competing interests, the different parties involved in a lien dispute, are equally protected.
Well, counsel says that all you have to do is go to the title company and do an escrow and get the insurance for that particular claim, and then the refinancing can, or the financing can go forward. So what's wrong with that?
There's no evidence in the record to suggest that's a possibility, Your Honor.
Why? I don't even know why there'd have to be, but I mean, why isn't that a protection from the mischief that I was worried about?
I don't know that that's even a viable option with regard to title companies. I don't know that. So the overarching purpose of the statute is to discharge, to clear title to the property while the lien is disputed, so that it is not held hostage for
Counsel,
months.
if I could direct your attention to one thing about the language of the statute that
Sure.
I have a question about, and it is that the plain language appears to me to permit suits on these bonds by parties prior to the filing of any lien. Because it talks about, first of all, do you agree with that? And then secondly, what are we to do with that? The statute talks about liens that are discharged if they've already been filed.
Your Honor, I think that pre-2005, you had this, general performance bond that most of the time it was filed at the beginning of a project, but the language was also broad enough at that time to allow the bond to be filed after a lien had accrued. And so, I guess I don't understand a scenario under which somebody would be permitted to file a claim against the bond before a claim arises.
The specific question is, can they file a claim against the bond prior to filing a lien?
If it's the type of bond that was filed in Eldridge, sure.
And your argument is that that's limited to that type of bond that's described in the first sentence of the statute, but not against the kind of lien that's described in the second clause, which
Correct,
you
Your
referred
Honor.
to.
Because the type of bond that you're referring to is essentially like a public works bond. It's a bond that's available for...
That's fine with your policy argument or your rationale, but from a statutory construction standpoint, how do you apply that later paragraph to only part of the first paragraph?
I guess
in other words, the language that Justice Stegall is giving to you, you say it only applies to the first part of the sentence, where it's the overall contract, and not the second part of the sentence in the first paragraph of the statute. I'm asking you how we get there as a matter of statutory construction. Why that later paragraph on discharge doesn't apply to both of your two kinds of liens that you're proposing.
I don't think in the case of the bond that's at issue in this case, I don't think it would be permissible to file a claim before a lien has arisen, either in the matter of the supplier coming to the contractor and saying, hey, you know what, we've got a claim, we're entitled to payment here. If we don't get payment, we're going to file a mechanics lien. I think the language of the statute is broad enough as soon as a claim arises, whether the lien has been filed or not, but you still have to have a claim which is disputed.
Doesn't that favor your opponent's position, though? Because if I could boil this down, this is a suit brought on the bond, right? That's what the statute says. These are suits brought on the bond. And all we're talking about are what are the elements of that claim and what are the defenses that are available. And you want to preserve the defense of an imperfect lien, or a lien that has defects, as a defense to the suit on the bond. Am I summarizing that correctly?
That is correct, Your
And
Honor.
so if that's the case, the statute appears, at least one reading of the plain language, is that it permits a suit on the bond without any filing of a lien. And that would seem to indicate at least that the filing of a perfected lien is not actually an element of such a suit brought on the bond. Is my question making sense?
It's a little bit foggy. I'm not sure that I agree with that, Your Honor.
Your position is that one of the elements of a suit brought on a bond is that you have a perfected lien.
In order to bring a suit on the bond?
Right.
No. Essentially, the whole purpose of this statute is to substitute the bond for the property. Counsel suggested that our interpretation adds confusion to the situation. It doesn't at all. All we're talking about is substituting the bond for the property. Nothing else changes. The supplier doesn't lose any of its claims or arguments. The owner, contractor, they don't lose any of their defenses. The property is freed up so that in this case it could be converted to traditional funding, and the supplier now has a guaranteed source of payment if the lien is proved valid. That's all that this statute accomplishes.
So, counsel, what you're saying, if I understand correctly, is that when it says such liens are discharged, those 4 words mean it's just the encumbrance on the property that's discharged, where other counsels say liens are discharged means it's all wiped clean, and the fact that it was perfected is irrelevant. And that's really the crux of what we're talking about, is what discharged really means. What's discharged? You say it's the encumbrance. He says it's any flaws.
Well, I think the use of the term discharge in the statute references the discharge of the lien from the property.
Such liens are discharged.
Exactly.
And you say the lien means the encumbrance.
Correct.
And he's saying the lien literally means if we didn't get it perfected, that's gone. And that's really the crux of what we've got going.
Counsel is suggesting that the filing of the bond results in the waiver of certain types of lien disputes. Right. And we believe there's nothing in the statute to support that argument. There's certainly nothing, just from a common sense public policy standpoint, that would justify differentiating between different types of lien disputes. And we believe we've suggested an interpretation that is consistent with the plain language of the statute and is a win-win that protects everybody's interests. So we would ask this court to reverse the Court of Appeals decision, reinstate the district court's decision granting summary judgment in favor of Putz Corporation and United Fire and Casualty Company.
Thank you, counsel.
Thank you, Your Honor.
We thank you both for your arguments this evening. The court will take this matter under advisement. That concludes our docket for this evening's session. Court is now adjourned. We look forward to seeing you in the reception area in about 5 minutes.